My dear friends, I am Dr. Waseem I Khan, Assistant Professor, Sri Shivaji Law College, Parbhani, Maharashtra, India. In today's lecture, we will start a new chapter of Law of Tort, that is Introduction and Essentials of Tort of Nuisance. So we will discuss all the decided case laws along with the essential. So let's start the topic. Tort of nuisance and its essential we will discuss in today's lecture. So in the previous lecture we have discussed the topic of defamation. So first of all we will discuss the introduction of nuisance, what exactly the nuisance is there. The word nuisance is derived from the French word neuter and the Latin word nuisere, which means to do hurt or to annoy. So this word nuisance is derived from the French word which is neuter and Latin word nuisere, which means to do hurt or to annoy. Suppose if by the act of mine, if my neighbor is feeling discomfort, if he is getting annoyed, then I will be liable for the tort of nuisance. So nuisance is nothing but to do hurt or to annoy. It is an action or omission, it is an act or omission interfering with the right of another to enjoy some property, causing damage or physical discomfort. So nuisance means if by the act of any person, if the person who is having a right to use or enjoyment of any property, if he is feeling discomfort due to the interference caused by any other person, if he is feeling discomfort due to the interference caused by any person, then it is a nuisance. Suppose by the act of mine, if you are feeling discomfort, if I interfere with the use or enjoyment of land which you are having, and due to which if you are feeling discomfort, if you are getting annoyed, I will be liable for the tort of nuisance according to this particular definition. Now we will move towards the definition of nuisance. The Winfield defines the term nuisance. A nuisance may be described as unlawful interference with a person's use or enjoyment of land or some right over or in connection with it. So according to Winfield, nuisance is nothing but a unlawful interference, and that unlawful interference is with the person's use or enjoyment of land. So if the person who is having a right to use or enjoyment of land, if in that particular right, if there is unlawful interference, it is called a nuisance. So the person who is having a right to enjoy the land, if any person cause unlawful interference in that particular right, it is called a nuisance. I am having a right to enjoy or use any land, and if you are unlawfully causing interference in that particular right, it is called a nuisance according to Winfield. Now Pollock defines the term nuisance. Nuisance is the wrong done to a man by unlawfully disturbing him in the enjoyment of his property, in some cases in the exercise of common right. So I am the owner of any land, I am having a right to use or enjoyment of that property, and if any person unlawfully disturbing me in that particular right by a wrongful act, then I will be entitled to claim a compensation by instituting a suit against that person, because right to use or enjoyment of land is a right of mine and no person will be entitled to unlawfully disturbing me. So if any person unlawfully disturbing my right to use or enjoyment of land, it comes under the category of nuisance according to Pollock. Now we will move towards the essentials of nuisance. The first essential of nuisance is right to use or enjoyment of land. So who will be entitled to file a suit for the tort of nuisance? Suppose if I want to file a suit for the tort of nuisance, the first essential I must prove if I want to get a compensation, and that essential is right to use or enjoyment of land. I have to prove that I was having a right to use or enjoyment of land. So suppose if I am the owner of any property, being an owner I am having a right to use or enjoyment of land. So until and unless the person proves that he is having a right to use or enjoyment of land, he will not be entitled to get a compensation under a tort of nuisance. So licensee without possession. Suppose by license person is having an authority to enter upon a certain place, but licensee doesn't have a possession, and the person who doesn't have a possession will not be entitled to file a suit for the tort of nuisance. The person who is having a possession only entitled to file a suit for the tort of nuisance, because the person who is having a possession is only having a right to use or enjoyment of land. So licensee having no possession will not be entitled to file a suit for the tort of nuisance, because he cannot prove the first essential, that is right to use or enjoyment of land. Guest of an occupier cannot file a suit. So guest also having no right to use or enjoyment of land, and that's why guest will not be entitled to file a suit for the tort of nuisance. Then person having actual possession. Suppose if the person is having a possession of any property, so being a possessor of that property, he is having a right to use or enjoyment of land. He can prove that he is having a right to use or enjoyment of land, and that's why the person having actual possession will be entitled to file a suit for the tort of nuisance, because he can prove that being a possessor, he is having a right to use or enjoyment of land. So first essential is right to use or enjoyment of land. Second essential is that interference. If the person is having right to use or enjoyment of land, and if there is no interference in that particular right, there will be no nuisance. If a person wants to get a compensation under the tort of nuisance, he must prove the first essential, that is the right to use or enjoyment of land, and after that he must prove that in that particular right there was a interference. Until and unless there is an interference in the right to use or enjoyment of land, tort of nuisance will not be there. So interference may be through noise, smell or pollution. Suppose if my neighbor is playing a song in the late night with a very high volume, then it comes under the category of interference. If there is a filthy smell, it comes under the category of interference. If there is a pollution, it comes under the category of interference. So until and unless there is an interference, and in nuisance the interference is indirect. In trespass, interference is direct. If I entered into the premises of any person without his permission, it is called trespass, because this is a direct interference. If there is an indirect interference, suppose if the person grows a tree on his land, and if the branches of the tree projects into our land, it is called indirect interference, and it is a perfect example of nuisance. So in nuisance there is a indirect interference. So interference may cause through noise, smell or pollution. Through encroachment it is also possible, that is the rainwater and branches. If the branches of our neighbor comes into our premises, it is a example of interference. Rainwater, if there is an outlet of our neighbor in our premises, it is an encroachment, and it is also comes under the category of interference. Build a house cornice, also an example of interference. This is a perfect example. In this image we can see that the neighbor plants a tree on his premises, but the branches projects into the land of another person. So it is an indirect interference, and it is perfect example of nuisance. Then causing physical damage to a land or something upon its setting of machine and vibration. Suppose if our neighbor set a heavy machineries in his premises, and due to the running of that machinery there is a vibration and there is a sound, and due to which any physical damage caused to our property. Suppose due to the vibration of that machine, if there is a crack into the wall of our house, then it is a interference, and through that interference there is a physical damage. So it is also an example of interference. Causing inconvenience, discomfort or annoyance by noise or by smell. The inconvenience or discomfort may caused through noise or smoke. So it is an example of interference. It may be through smell or noxious fumes. So the first essential is right to use or enjoyment of land, and second essential is interference. And now we will move towards the third essential, that is interference must be unreasonable. We have discussed the two essential. Right to use or enjoyment of land is the first essential. Second one is the interference, and third one is interference must be unreasonable. Suppose I am having a right to use or enjoyment of land, and if there is an interference, but that interference is not unreasonable, if that interference is reasonable, then I will not be entitled to file a suit against my neighbor for the tort of nuisance. But when I will be entitled to file a suit for the tort of nuisance? Only when if the interference is unreasonable. So not only the interference, but that interference must be unreasonable if I want to get a compensation for the tort of nuisance. So noise of radio in a very low, not unreasonable. Suppose if our neighbor is playing a song on a radio in a very low volume, though it is an interference, but it is not unreasonable. But he is playing a song with a very high volume, then definitely it is an interference, and that interference will be treated as unreasonable. So when person will be liable for the tort of nuisance, if that interference which he caused is unreasonable, then only he will be liable for the tort of nuisance, otherwise not. Suppose if there is a volume of that particular song is very high, it is unreasonable, and if it is very low, it is reasonable. This is an example of unreasonable and reasonable interference. The fourth essential for the tort of nuisance is damage. Suppose if I am having a right to use or enjoyment of land, and if there is an interference in that particular right, and if that interference is unreasonable, but I have sustained no damage, I will not be entitled to get a loss. When I will get a loss? If I prove the fourth essential, that is a damage, by the act of any person, by the unreasonable interference caused by any person, if I sustained any kind of damage, then only I will be entitled to file a suit and I will get a compensation, otherwise not. So actual damage is to be proved. If I want to get a compensation, I must prove the actual damage. I must prove that I am having a right to use or enjoyment of land, and my neighbor has unlawfully unreasonable interference in such a right, and due to which I have sustained a loss. Suppose if my neighbor set up heavy machineries on his land, being a owner of my property, I am having a right to use or enjoyment of land, and when due to the running of that particular machinery there is a strong vibration, and due to which there is a crack in the wall of mine, interference is there, unreasonable interference is there, and the damage caused to my property is there, then only I will get a compensation, otherwise not. So these are the four essentials of tort of nuisance. I hope you understand this topic. If you understand this topic, please subscribe my channel, hit the notification button, hit the like button, and share this video with your friends. Thank you very much.